One area of estate planning that's often overlooked is healthcare planning. People tend to focus on who gets what after they pass away, but the question I often ask is this: what happens if you're alive but you can't speak for yourself? Hi, I'm Jim Fletcher, Georgia estate planning attorney. In Georgia, there are several documents that come into play when it comes to medical decisions and access to information. They sound similar, but they serve different purposes. So let's walk through them and let's talk about why each one matters. So the first is a healthcare power of attorney. This names the person who can make medical decisions for you if you're unable to do so yourself. This can include decisions about treatment, doctors, facilities, or maybe even end-of-life care. Without this, your family may have to go to court to get authority to act on your behalf. That takes time, it costs money, and may create conflict during a stressful situation. Next is a living will. A living will doesn't appoint a decision maker. It expresses your wishes about life-sustaining treatment, such as if you're terminally ill or permanently unconscious. It answers questions like, do you want artificial nutrition, hydration, or life support continued? The goal is to remove guesswork, so your loved ones aren't left wondering what you would have wanted. Then there's a HIPAA authorization or medical release. This allows certain people to access your medical information or talk to your doctor. It does not give them decision-making authority. It just allows doctors and hospitals to talk to them or give them records. Without it, even close family members might be denied information due to privacy laws. This is especially important if your healthcare agent needs access to information before they formally step in to make decisions. Now here's where Georgia does things a little differently. Georgia has a document called the Georgia Advanced Directive for Healthcare. This is a single document that combines the healthcare power of attorney and the living will into one. It allows you to name your healthcare agent and state your wishes regarding life-sustaining treatment all in the same form. But it's recommended to do a more general healthcare power of attorney and living will because in some states that's the document they're looking for. If you're traveling or move to another state, we want you to have the documents they expect there. So let's put this into a real world scenario. Imagine you're hospitalized in Georgia after an accident and you can't communicate. Your spouse wants to talk to the doctors and make decisions. If you have a properly executed Georgia Advanced Directive and a HIPAA authorization and your wishes are clear and your agent has authority and access, but without this, your loved ones may be stuck waiting or forced into court proceedings just to help you. So these documents aren't about giving up control, they're keeping control. You're making sure the right person who you trust is speaking for you and your wishes are known and your family isn't left guessing or fighting. Healthcare planning is just as important as financial planning. In Georgia, having the right documents in place can make an enormous difference when it matters most.